voiceover provided by Windows 7 Microsoft text-to-speech engines, via Microsoft Narrator L, within the Ballot Volta program, reading back a text, made through newocr.com, from a JPEG extracted from a PDF file, that was badly printed without embedded text, by a stupid evasive bureaucrat at the ADF that was then transliterated by waptek for factual transmission to you the viewer and listener.
U.S. Department of Justice, Bureau of Alcohol, Tobacco, Firearms and Explosives, Martinsburg, Virginia, 25409. A. TF.G. O. V/903050. MCP 3311/2010-339 on February 25, 2010. This refers to your recent correspondence to the Bureau of Alcohol, Tobacco, Firearms and Explosives, the ADF, Firearms Technology Branch or FTB, which included your submitted sample of a .22 caliber, long rifle barrel insert designed for installation in a flare gun. Specifically, you ask about 1. The classification of the submitted devices itself and 2. The lawfulness of installing the subject device in a flare gun. As background, the amended Gun Control Act of 1968 G.C. A18 U.S.C. 921A3 defines the term firearm to include any weapon including a starter gun which will, or is designed to or may be readily converted to expel a projectile by the action of an explosive, and the frame or receiver of any such weapon. With respect to the definitions of handgun and pistol under federal statutes and implementing regulations, you may be aware that G.C. A. 18 U.S.C. 921A29 defines handgun as, in part, a firearm which has a short stock and is designed to be held and fired by the use of a single hand. Additionally, 27 CFR 479.11 defines pistol to mean a weapon originally designed, made, and intended to fire a projectile, as in a bullet from one or more barrels when held in one hand, and having one or more chambers as an integral part of, or permanently aligned with, the bore, and a short stock designed to be gripped by one hand and at an angle to and extending below the line of the bore. Further, the National Firearms Act NFA 26 U.S.C. 5845A5 defines the term firearm to mean, in part, any other weapon, as defined in subsection B, and 26 U.S.C. 5845E defines any other weapon as any weapon or device capable of being concealed on the person from which a shot can be discharged through the energy of an explosive, a pistol or revolver having a smoothbore designed or redesigned to fire a fixed shotgun shell, and weapons with combination shotgun and rifle barrels 12 inches or more, and less than 18 inches in length, from which only a single discharge can be made from either barrel without manual reloading, and shall include any such weapon which may be readily restored to fire. But such term shall not include a pistol or revolver having a rifled bore, or rifled bores, or weapons designed, made, or intended to be fired from the shoulder and not capable of firing fixed ammunition. With regard to your specific concerns pertaining to the submitted sample, you ask the following questions paraphrased, which are followed by FTB answers. Question 1 reads, is the submitted sample rifled barrel insert device by itself subject to regulation under federal firearms statutes? The answer is no. As confirmed in our examination, the submitted device, in and of itself, is not subject to regulation under the provisions of the G.C.A. or NFA. Question 2 reads, would it be legal for an individual to install the submitted device in a flare gun for the purpose of firing .22 caliber cartridge ammunition? And the answer should have been yes. Unless otherwise prohibited to have a firearm, it would be legal for an individual to install the submitted device in a flare gun for the purpose of firing .22 caliber cartridge ammunition, but the ADF obviously wanted to avoid saying the true and factual answer, so let's read the parts in the right order to decode this evasive response. The installation of the submitted device in a flare gun would create a firearm as defined in 921A3, and possession of the submitted device and a flare gun, together, could also constitute possession of a firearm. And the installation of your sample device in flare guns would bring them under GCA controls. And finally, We recommend verifying that use of the submitted device in a flare gun does not violate particular state laws or local ordinances, and further all the above would impact certain individuals who are prohibited from possessing firearms, and such persons could not lawfully install this device in a flare gun for their personal use. We trust that the foregoing has been evasive to your request for evaluation. If we can be of any further assistance, please contact us. Sincerely yours, John R. Spencer, Chief, Firearms Technology Branch.
And now, I thank you for watching. Have a good day and good luck with that.